All right. Good morning, everyone. I'm going to give it just a minute and make sure everybody is hooked up here. It looks like a couple of people are still joining. Okay, I think we have everybody. If somebody joins us, that'll be fine. But good morning. My name is Alan Lilly, and I'm the presiding hearing officer at the State Water Resources Control Board Administrative Hearings Office. And I will be the hearing officer for this matter. With me this morning from my staff, my office, are Kyle Woldridge, Skylar Anderson, Megan Nyes, Nicole Mullen, and Amy Blanc. And they will be running the recording and doing the other logistics. And I appreciate their help very much, as always. As stated in the notice, this is the pre-hearing conference on which will be leading to the hearing on the pending petitions of the Garberville Sanitary District to change its water right license 3404 and its water right permit 20789. And the hearing is scheduled to begin on June 15. The purpose of today's conference is to go over logistics and make sure we have everything in order for going forward. So as stated on page 20 in section 12 of the notice of public hearing and pre-hearing conference, the Administrative Hearings Office has not ordered a court reporter for this pre-hearing conference and will not be ordering a court reporter for the hearing. Any interested party may order a court reporter at that party's own expense. The process for today, I will be doing most of the talking, and I will call on people to speak one at a time, of course. And if you have something to say and I haven't called on you, then please let me know. You can either raise your hand electronically. I think there's a Zoom feature for that, or you can do it the old-fashioned way and just raise your hand so I can see it on the screen. And if I don't notice you and you think I'm not going to see you and you have something you need to say right away, you can speak up. But obviously, I'd prefer we have it a little more orderly if we can. And I will try to pause from time to time so you have a chance to raise your hands if you have questions. I see most of you have already done this. Obviously, a year into the COVID pandemic, we're all getting pretty familiar with how Zoom works. And all of you have put your microphones on mute, which I appreciate. We've had problems in the past with feedback when some people are not on mute while they're not speaking. So, and of course, I'll remind you to go off mute if you're trying to speak and you haven't turned off your microphone, as people often have to remind me. During the hearing, I request that you refer to me as Mr. Lilly, and I will refer to each of you as Mr. or Ms. with your last name. This is not a court proceeding, so you do not need to call me Your Honor, but I do want to keep it a little bit formal, so let's use Mr. and Ms. to refer to people. And so when you're referring to other people, please try to avoid using their first names, even though I don't know any of you, but many of you know each other, I'm sure, from proceedings over the years. So let's try to keep it a little bit formal. So with that, I'm going to go down the list, my list of the people I have who have filed notices of intent to appear either on behalf of yourselves or on behalf of parties you are representing. And I want to just make sure I see who we have here and if we make sure I haven't missed anybody. So with that, I will start with the Garberville Sanitary District. There were 3 people listed on the notice of intent to appear. First is Jenny Short. Ms. Short, are you here today?
Yes, I am.
Okay. And I noticed your video was on earlier, and you don't have to have your video on. I prefer you do, but you don't have to when you're not speaking. But there we go. Now we've got your video. Or if I have to have mine on, it's better if you do as well. I will say the pandemic has obviously caused a lot of problems for all of us in this country, but on the other hand, Zoom hearings have turned out to be a benefit. And I think today is a perfect example. I think by doing this by Zoom, we saved all of you many, many hours of driving to Sacramento, which is the way it would have been done in the old days. And we can do this fine over Zoom. So it's 1 hour out of your day rather than a day and a half counting travel time. I think that's a benefit, and we'll do the best we can. But yes, I do appreciate if you can be on video. It just helps me connect a little bit better with you. So anyway, that's a long way of saying good morning, Ms. Short. Ralph Emerson, also on behalf of the district. I see you there, Mr.
Yes.
Emerson.
Hello.
Good morning. And then Russ Gans is listed as the attorney for the district. I don't see him here. Mr. Gans, are you here today?
He's not, and he will only attend the hearing itself if it becomes necessary.
Okay, thank you. And that's fine. All right, and then Cody Cox on behalf of, I think it's Redway Community Services District. Mr. Cox, I see an icon for you. Can you let us know if you can hear me and if you're there? You have to go off mute though.
Sorry about that. Yes, I'm here.
Good, now we can see you too. So good morning, Mr. Cox.
Good morning.
And then Kristen Vogel, I see you appearing on behalf of yourself. Good morning. And just go off mute so we can make sure your microphone's working. Still on mute.
Good morning, Mr. Lilly. I think you can hear me now.
Now I can hear you. Thank you. Good morning.
Thank
All
you.
right. And then Edward Voice, Mr. Voice, I see you. Can you just go off mute and make sure we can hear you?
Yes, good morning.
Yes, good morning, Mr. Voice. Linda Sutton, excuse me, it looks like there's somebody else from Redway who's waving her hand. Please go ahead. I'm sorry.
So this is two board members from the Community Services District. I'm Robert DePerna. This is Linda Sutton.
Okay, so give me your names again, please.
Oh, go ahead. Linda. So I'm Robert DePerna. I'm a director for RCSD, and next to me here is Linda Sutton, who is also a director here at RCSD.
Okay, and please, Mr. DePerna, how do you spell your last name?
D-I-P-E-R-N-A. Hope that is clear. P-E-R-N-A. Good
Oh, okay,
Italian,
good.
yeah, good Italian boy, complicated. So.
Okay, good, DePerna. So good morning, Mr. DePerna and Ms. Sutton. And so Ms. Sutton, I did also have an NOI that you'd filed on just on your own half. Are you going to appear personally in this hearing or just on behalf of Redway CSD?
I'd like very much to be able to do both. And I was hopeful I would find some place where I could go, where I could do it on my very own, but then, you know, resources down here are very limited. And Cody thought that I could participate for both, in both roles.
And that's fine. You certainly can participate in both roles. I will just ask you to, when you are participating, mainly during the hearing more than today, to make it clear when you are speaking on your own behalf and when you are speaking on behalf of the district, just so we're clear about that. But it's fine for you to appear in both roles as long as we're clear about that.
It is, but it's also a situation where concerns often overlap.
All right, well, we will have to do the best we can about
Yeah.
that, but we can.
I appreciate that, Mr. Lilly.
All right, well, we can be flexible and we certainly will. All right, so I did receive a notice of intent to appear from Colette Metz-Sanchi on behalf, who said she's the executive officer of Humboldt LAFCO. But I don't see Miss Sanchi, although we do have one phone number that's not identified. Miss Sanchi, are you here this morning?
Mr. Lilly, she's also not here. She intends to attend the hearing itself and explain the CEQA aspects of this project on behalf of the district.
Oh, so is she going to be a witness for the district, not independent?
Yes, she is just going to be a witness. She won't do any opening statements or any of that part.
Okay, so we will not list Humboldt LAFCO as a separate party then?
Yeah.
Okay, Carl Hubbard filed an NOI. Mr. Hubbard, are you here? Holbert, excuse me. I can't read my own writing. Mr. Holbert, are you here this morning? So it looks like Ms. Hino Barras, do you have something to say for Barasa? Do you have something to say on behalf of Mr. Holbert?
Thank you, Mr. Lilly. Yes, he plans to attend the actual hearing, but he was not able to be here today. He's a fellow board member on the Southern Humboldt Community Park Board with myself.
Okay, and is he going to appear on his own behalf or on behalf of the park?
On behalf of the park.
Okay,
And
and while
may
we're,
say something, we're not sure at this point.
okay, and that's fine. You don't have to decide that. It's better to be on the list, and then if you decide not to participate, that's a lot easier than the other way around.
Mhm.
Okay, so while you were actually next on my list, so Ms. Hino Barasa and then also Laura Cochrane is listed as NOIs for the park. So I don't see Ms. Cochrane on the list here today. So is it just you today, Ms. Hino Barasa?
She's calling in. Actually, she just unmuted to speak.
Okay, go ahead. Ms.
Hi, good morning.
Cochrane. Are you
Hi, good morning, Mr. Lilly.
415-608-5363?
Yes, sir.
Okay, so good morning. And my staff, which knows how to do these things, I have no idea how they do it, but they're quite good. They will change that so our display has your name rather than your phone number. That will help me remember, but that's certainly fine. So I just want to confirm, Ms. Cochrane, you also are appearing on behalf of the park.
Yes, that's correct.
Okay, so and for whoever on my staff is going to do it, it's Laura Cochrane. It's Cochrane. And I'm pretty sure they can change that just so it'll be clear on the recording. Okay, I also received a notice of intent to appear. Let's see, I'm sorry, Ms. Vogel, I already asked you, you're appearing on behalf of yourself, is that correct? Yeah, okay, good. And then I also, sorry, I'm jumping around here a little bit, but I'll get organized. Megan Joyce also filed an NOI. I don't see Miss Joyce this morning. Does anybody know if she's going to participate?
Yes, Mr. Lilly. Megan Joyce is also a board member of the community park, and like Carl Holbert will be on the hearing call, but may or may not speak.
Okay, so I'm going to list Carl Holbert, you, Ms. Hino Barasa, Laura Cochrane, and Megan Joyce, all as board members who will potentially participate on behalf of the South Humboldt Community Park, but not individually.
Yes, thank you.
That's one of the reasons we do these pre-hearing conferences, is so we can sort these things out, and that will be good. Okay, so and I had Robert Paterna and Linda Sutton on behalf of Redway CSD with Mr. Cox. Okay, I think I have this all sorted out. Have I missed anybody or not called on anybody who is participating today? And I'm sorry, Mr. Angier, have I called on you? My notes are confused here. I don't see you on my list. Are you participating as a party, or what's your status? You have to go off mute too.
That's correct. I'm participating. I didn't file to participate, but I am participating today.
Okay, do you plan to participate in the hearing?
Yes.
Okay, you're going to have to file a notice of intent to appear. Have you received the notice of hearing?
No.
Okay, well, do you have access to the State Water Board's website?
Yes.
Okay, you can go, if you go to the home page and then go to programs, we have the benefit of being listed first because we're beginning of the alphabet. If you go to Administrative Hearings Office, You pretty quickly can find the link for the Garberville Sanitary District matter and the notice of hearing. And then in that, it's a long document, but in it is a notice of intent to appear form, which is good for you to fill out so we have your contact information. And I certainly will allow you to participate. You were supposed to file the NOI by April 30th, but you're here today, which is well before the hearing, so that's not going to be a problem. But it would help us if today you could give us both your mailing address and your email address. Why don't you start with email address and say it slowly.
Email address. It's
Yes.
Ron Angier, that's run together @gmail.com.
Okay, no punctuation or anything?
No,
And capitalization, or that probably doesn't matter.
no.
Okay, and then what's your mailing address?
P.O. Box 1821, Redway, California, 95560.
Okay, P.O. Box 1821, Redway, California, 95560. And it's Ron Angier, ANGIER @gmail.com.
ANGIER, that's correct.
Yeah, okay.
Thank you.
And the reason I want to get that today is I want to get you on our service list right away.
Perfect.
And we will, as for everybody, except for, we had one person who did not agree to email service, but for everyone else, it's going to be by email. Linda Sutton did not agree to email, but everyone else has agreed to email service. So we will do it that way. And I will certainly explain that. And I don't know, Mr. Cox, maybe you can tell me, is Linda Sutton is not here today, but is she planning to participate solely as a director of Redway CSD or also personally?
She's here.
Oh,
We're here together.
oh, that's right. I don't have a label for you because it just says Redway. So Ms. Sutton, are you appearing just as the director of Redway?
No, I'd like to be able to appear both as a single protest and also as a board member.
Okay, and I'm sorry, you did tell me that earlier. My notes are a little garbled. And you,
No, I appreciate you clarifying that. And the only reason the issue of receiving information electronically is that I am not connected.
right. And so we will mail copies of things to you. It'll be slower, especially between Sacramento and Redway. But we will do that. That's certainly, you're right. But for everyone else, it's going to be by email. It's, for people who have email, it's quicker, but we certainly can accommodate that.
I understand that, Mr. Lilly.
Okay, so I hope I've gotten this all down. My staff is very good at taking notes, and if I don't have some of this right, they will help me. But
Mr. Lilly,
does anybody,
Can I ask
I was
a
just going to say,
question?
excuse me, Ms. Short, please go ahead.
I just wanted to clarify because Mr. Angier is new to the process, at least from the sanitary district end. Is he just going to be an interested person, or because he wasn't a protestant? Can you clarify?
Yes. The hearing process allows people to participate as parties, even though they did not file protests. We will address, if necessary, whether there are any limitations on their participation. I think the hearing notice covers that. But as necessary, we can cover that during the hearing. My normal view, though, is that anybody who wants to should have an opportunity to participate as far as presenting witnesses and evidence and making their arguments, whether or not they filed a protest. This is the State Water Resource Control Board obviously is a public agency, and we welcome public input. We certainly don't agree with everything that everybody says, but we welcome giving everyone the opportunity to participate in the process. So that's my initial reaction, is that anybody who has filed a notice of intent to appear, or in Mr. Angier's case, will be filing an NOI, may participate as a party. Okay. So anything further, Ms. Short? Okay, if you don't mind taking your hand down, then if you have a question later, you can raise it again electronically. If you can figure out how. And you are on mute. There you go. Okay, your hand is down. Thank you. And I have to confess, I still have to figure that out. And it's different on Zoom than on Teams. So we have to all get through there. All right. That was a little laborious, but I think we're there. Does anyone else have any? And just so you know, after this pre-hearing conference, I will be preparing a pre-hearing conference order. And among other things, I'm going to list all the parties to make sure I have it right. And of course, you can let me know if I get something wrong. But with that, does anyone else have any initial questions about the process before we dive into the meat of it? Yes, Ms. Hino Barasa, please go ahead.
Thank you. Mr. Lilly, I did want to mention that we actually had other community members that were interested in participating on behalf of the park, because it is used by so many members of our community on a daily basis. But we understood that deadline to be hard and firm, and many of them were not able to submit the paperwork in time. But it sounds like, based on your comments today, there is a window. I would just like more clarification on that, because we certainly don't want to bog the process down with unnecessary information. But if others are being allowed in after the deadline has lapsed, can you just comment on that for me? I appreciate it.
Yeah, I think there's a good process for the people you were talking about. And that is, and this is actually listed, I know this hearing notice is long and there's a lot of legalese in it. So if some of you had trouble, I mean, I always think of this, it's like when I get a form from the IRS and I read it and it's like, okay, those are all words of the English language, but they don't make any sense to me. And I'm sure some of you may feel that way about the notice of hearing. Hopefully we're not that bad. But anyway, on page 12 in section 4, there's a discussion of policy statements. And this is something where interested people who are not parties may submit statements expressing their views on the issues. And they can either have written statements, which they can submit before the hearing or at the beginning of the hearing, or they can present them orally. We do usually limit them to 5 minutes. And if people want to present a written statement and then provide us an oral summary, that's fine as well. So what I recommend is that you talk to all of the people who are interested in participating and explain to them about the opportunity for policy statements. And if that's sufficient for what they want to do, then they can submit those. And that usually is a pretty good way for people to be able to express their views. They're not formally parties. They're not under oath when they testify. They can't cross-examine people and all that, but they can express their views, which is usually what I think the people you're talking about want to do. But I would ask that you ask if they can just submit the notice of intent to appear form. And there is a box, option 1 says we intend to present a policy statement only and not to participate as a party. And it just helps me to have a list of everyone so I can make sure to call on them. So please ask them to do that. The sooner the better that they get those filed, but I'm not going to hold them to the April 30 deadline for those. Does that make sense?
Yes, and may I ask one more question, Mr. Lilly?
Yes, please.
Since many of them have jobs and aren't able to attend, could that just be submitted in writing and then read by a participating party on their behalf? It
absolutely may be submitted in writing. Excuse me just a second, I've got a beep going here. Somebody else can just note it. I don't know that they need to read the whole thing. I mean, I can read.
Okay.
But
okay.
It does make sense for somebody to make sure it's in the record and that I have it.
Okay.
So, but absolutely, I understand with time constraints, if people want to do that, that's fine. And we will consider it, absolutely.
Okay, thank you very much.
And I don't know whether that applies to anybody who's on here today. I think all of you checked the boxes saying you want to participate as parties, which is fine. Is there anybody who wants to just present a policy statement and not participate as a party? Okay, and you can change your mind. You can go that way, change party to policy statement later if you want to, but I will go off the assumption all of you want to participate as parties. And the main difference is it means when you testify, you are under oath. You have to take the oath before you testify. You're subject to cross-examination. The other parties I may ask you questions, but you do then have the right to cross-examine, or that is, ask questions of other parties as well. So it's a different level of participation. Okay, so with that, are there any more questions before we go forward? And we'll certainly have chances to raise more questions if things come up. Anything else for now? All right. The next thing I wanted to mention, and it is in the hearing notice on pages 7 and 8, and this is about ex parte communication. So we try to avoid using Latin in the law these days. That's an artifact of a prior era, but ex parte remains. And basically what it means is when one of you contacts me or one of the members of my staff and starts talking about the hearing and nobody else is there, or you send an email to us without sending copies to everyone else. And that's just really, I just really try to avoid that. A lot of times it's innocuous. Somebody's just saying, hey, I have a question about how to label my exhibits and I can't figure out what your notice wants. But sometimes it's more substantive, and sometimes you may not realize that what you're saying can have substantive effects, and other people do care about that. So, and I for many years, I was a lawyer who appeared in front of the Water Board, and I was pretty sensitive to that. I sometimes thought other parties or their attorneys were talking to the board staff and I wasn't involved, and it just sort of didn't seem fair to me. So as a result, I'm very strict on this rule. Certainly today, it's no problem. Everybody can talk. And if you ever want to send me an email, if you have a question, I mean, don't do it if you don't need to, but if there's something you need to communicate about, just send me an email and just include all the other parties as CCs. And then everybody knows what the communications are. And with Ms. Sutton, we do ask that you drop a paper copy in the mail to her since she doesn't have email. And then there's just no question. And of course, when I reply, I'll do a reply to all and paper to Ms. Sutton so that we all have open communication. I just think everyone's going to have a lot more confidence in the process if it's open in that regard. You may get overkill, you may get more emails than you want, but that's the way I prefer to do it. You can send the emails to the Administrative Hearings Office email address, which is in the notice. I will get them, but just please CC everyone else. If you want to, you can send paper copies to everyone. We will have a service list with mailing addresses, but I know email is a lot easier, and that will be fine. So, as I say, the pre-hearing conference order I'm going to prepare will have a new service list, which will list everyone's email address and mailing address. So it shouldn't be too hard for you to include everyone as CCs on your email. Okay, next thing on my list, we have been getting emails where we were a CC on different email communications between and among the parties. And my colleague, Nicole Kunze, did send a letter on April 8th while I was out to the parties, but I just want to clarify on that. We're more than happy to have all of you communicate with one another. You don't have to, if you want to communicate just with one other party and not any others, that's fine. If you can talk about settlement, that's even better. If you have questions about exhibits and so forth, that's fine. But normally you don't need to include us as a CC. Unless there's some reason where we need to know what's going on, it's better not to load up our administrative record with a lot of extra CCs. If you do, we'll put them in the administrative record. I don't know whether or not we'll read them. They're they're not really something I can use for the hearing process because they're not under oath. They're not, there's no way to do any cross-examination or anything. So it's just sort of a burden. So again, communicate amongst one another. Please go ahead, do that whenever you want, but don't CC us unless you think there's a reason to. And then, as I said earlier, if you're sending something directly to us, then do CC everybody else. One other thing on the pre-hearing stuff, we do have our AHO FTP2 site, which you're familiar with. It's listed in the hearing notice. And some of you have uploaded files to that site already, which do not have any labels on them. I don't really have any way to deal with those. I mean, I'll leave them in the administrative record, but I don't know who submitted them or what their purpose is. So if you did upload files earlier to the AHO FTP2 site, and you want to have those files be exhibits, you're going to have to resubmit them as exhibits. It won't be hard, but just give them the proper label and numbers, and then we'll put them in the folder for your exhibits and we'll be able to process them. So any questions on that before I get into the pre-hearing conference issues?
Mr. Lilly, I do have a question about exhibits.
Okay, Ms. Short, let me talk about exhibits first, and then let me know if your question is answered.
All right, sounds good.
And if it's not, then you can state it. I'm getting to exhibits, so I think I may answer your question, but if I don't, let me know.
Okay, I thought you were moving on.
I am moving on, but I get to talk first.
All right.
Okay, so the pre-hearing conference, just so you know, I'm going to talk about the hearing issues, the process, the pre-hearing process, which is mainly submittal of exhibits, and then the hearing process procedures, and then anything else we need to talk about. So I'm going to start with the hearing issues. And I'm going to read them just so we all have them. I know some of you, most of you have probably read them already, but in case you haven't, and just to familiarize yourself, this is what we're planning to have the hearing address. Issue number 1, should the State Water Board approve Garberville SD's petitions to change the authorized place of use for license 3404 and permit 20789. And the sub-issues under that are A, would the State Water Board's approval of these petitions result in injury to any other legal user of water? B, would the State Water Board's approval of these petitions unreasonably affect any fish, wildlife, or other in-stream beneficial use? C, would the State Water Board's approval of these petitions be in the public interest? D, would the State Water Board's approval of these petitions cause the initiation of any new water right? E, what is the status of Garberville SD's actions to comply with California Environmental Quality Act, CEQA, for these petitions? And then issue 2 is, if the State Water Board grants these petitions, what new terms and conditions, if any, should be added to this license and this permit when the petitions are granted? And under that, sub-issue A, should the AHO hearing officer include the attached draft amended license 3404 and draft amended permit 20789 in the draft proposed order the hearing officer will transmit to the board? And B, if so, should the AHO hearing officer make any changes to these drafts before including them in the hearing officer's proposed order? And before I ask for comments on those issues, I do want to note that Ms. Short sent an email to Michael Meza in the State Water Board's Division of Water Rights Unit on April 4th, which asked some questions about one of the terms in the draft permit and draft license regarding the cannabis cultivation policy. And I'm going to discuss that email and that process for addressing that a little later on today. So if you can put that issue on hold, my question is, other than that, does anybody think that there are any issues that need to be addressed during the hearing beyond those that we have stated in the hearing notice? And if so, you can just raise your hand. Those issues are stated fairly broadly, so I think they should cover everything today. Okay. Hearing none, I will go forward. Let's talk about exhibits. It is important. I know it's a lot of words, but we've written it out as clearly as we can. It's very important that you read section 7, which is on pages 14 and 15 of the hearing notice regarding exhibits. It discusses how to format them, how to prepare your written proposed testimony, and how to label and number your exhibits. And I will put this in the order as well. But for example, for Garberville Sanitary districts, those should be labeled Garberville SD1, Garberville SD2, and so forth. And for parties, for example, Mr. Voice, I think you label your exhibits Voice 1, Voice 2, and so forth, and the same for everyone else. And again, there's the numbering system. It doesn't really matter what number you give each exhibit, just mainly for each exhibit to have a number, because then it's easy for us to refer to them. As far as how to file them, section 8 of our hearing notice, which is on pages 15 through 17, describes how to file them. Certainly the easiest way for you and for us is if you upload them to the AHO FTP2 site and as electronic files, and then we can make sure to get them into the record and post them on the AHO FTP site where everyone can view them. That's the fastest, less paper, you don't have to mail them and all that. Again, with the one exception of mailing paper copies to Ms. Sutton. And just so you know, we will set up a separate folder for each party within the Garberville Sanitary District matter folder, which is already on the AHO FTP2 site. And that way you can each put your exhibits into your own folder. That will help us keep them better organized. So we will open those folders and then you can just upload them to the folder with your name on them. And so let me just check my notes here. Yeah, as I said before, if you uploaded something before without a name or number, just upload the file again with your name and exhibit number. So we've got it. If you do it that way, you do not need to serve paper copies on the other parties who have agreed to electronic service. That would mean just mailing paper copies of your exhibits to Ms. Sutton. We do ask that you mail 2 paper copies of each exhibit to our office so we can have those for our paper administrative record. As long as you upload them by the deadline, which I think is June 2nd by 4 p.m. I don't mind if you also drop them in the mail on June 2nd, even though it means we won't get them until the 4th or 5th. So don't worry about that. But if you do send them by paper and you do not upload them, then they have to get to us by June 2nd. So again, that's an advantage of doing it electronically. So that is the main thing I was going to say about exhibits, labeling, and filing. Does anybody have any questions about those?
Mr. Lilly, could I just
Yeah.
make sure?
Please,
I
go
just want to
ahead.
make sure I understand what you're saying, because some of
I
the
rattled it
documents,
off pretty quickly, so please ask your question.
well, some of the documents that potentially could be uploaded could be hundreds of pages. And are you saying that you want the party that uploads them to print out all hundreds of pages, 2 copies, and mail them to your office in addition to uploading them to the FTP site?
That is what I normally prefer. If it's 100 pages, I don't think that's unreasonable. If it's 1,000 pages, I get it. So let's do this. If you have some specific exhibits that you think it's too burdensome to print the whole thing in paper, send me an email, and again, well before the June 2nd filing deadline, and CC all the other parties and mail a copy to Ms. Sutton, and just say, this exhibit is 300 pages long or 3,000 pages long. I'd prefer not to mail a paper copy. Is it okay if we just use the electronic file for this exhibit? And then I will respond to that. And that's
Okay.
not just for you, that's obviously for any party. Yeah, I
Are
mean, if
you
it's
gonna-
something like an EIR or some long document where you're going to end up citing to 5 pages in a 400-page document, we probably don't need the whole 400 pages in paper.
Okay, are you going to address as a separate issue the existing documents that are on the regular FTP site that are in your administrative records?
Let me go, that's a good question, and I didn't have that on my notes, so let me address that now. The answer is, if we've already posted something and it's already on the AHO FTP site, you don't need to refile that as an exhibit. It's already in the record, and then either your testimony can refer to that or your closing brief can refer to that. So the answer is no, you do not need to refile those, and just refer in the record. I do request, if you want to refer to those exhibits, just make sure to use the exact file name that's in the AHO FTP folder so we know what file you're referring to. But you don't need to refile docs that are already on the AHO FTP folder. Does that answer your question?
It does, and it leads me to the second part of my question, which is that when I submitted the petition to change the place of use, part of the instructions I was given was not to print the entire draft EIR and final EIR for the park. And so they asked that I put it onto a CD and mail it with the rest of the papers that I did print out and provide. None of the stuff that was on the CD appears to be part of the administrative record at this point, which is concerning to me because that was a significant amount of the CEQA.
Yeah, and that's because it's probably somewhere in the Division of Water Rights files and not in my office's files. So for things like that, what I ask is either if you can upload it to the HOFTP2 site, that's with an exhibit label, that's the best. If it's too many megabytes to do that, then mail a CD. It's so archaic, but it still works. A flash drive or a CD, preferably a flash drive. I'm not sure we have CD readers anymore. We do have flash drive readers, and we will upload it to the FTP site. So I think there's something in there about you can do that. But again, if you have any questions, just send me an email with CCs to everyone else and just say, is it okay if I file exhibit Garberville SD7, which is the draft EIR? Is it okay if I send you a flash drive rather than uploading it or sending you a paper copy? And I will get back to you on that. And just tell me how many pages roughly it is and why you want to do it that way.
Do you know if there's a limit to how many megabytes the FTP site will allow you to upload? I don't think there's, because it's an upload, it's not an email attachment. So I don't know. I'll see Mr. Anderson, Schuyler, who's on my staff. Can you go off mute and just tell me if you know if there's any megabyte limit to that?
I don't know what the limit is, but we haven't had a problem with people uploading long videos. I believe it's probably in the gigabytes. It's very large, so it shouldn't create.
Okay.
Okay.
Okay,
Yeah,
thank
these
you.
are like about 75 to 80 megabytes a piece, but the two documents are probably 1,200 pages amongst them.
Yeah, if you can see if you can upload them, and if you can't, then send me an email and just say, I'm going to send you a flash drive. I mean, frankly,
Okay,
it's
will
probably,
do.
it might be easier to upload them than to find a flash drive that would hold that many megabytes or gigabytes. So, I mean, one way or another, we want to get them in the record so I can read them and so all the other parties can read them.
Okay, I will try the upload first, and if I have problems, I will let you and everybody else know.
Great, thank you.
Thank you.
It's a fair question, and certainly it applies to anyone else. You know, we try to have procedures that work, but obviously with big documents, sometimes we have to make exceptions. So we will do that. Mr. Voice, are you raising your? No, you're not raising your hand. You have to go off mute though to tell us.
I did have a question.
Go ahead, please.
Pertaining to my original protest and all the attachments that I made in that protest. is that something I can refer to, or do I need to upload all of those attachments I made with my initial protest? How does that part of it work?
I'll tell you what, let me just see if I can click over here to the I'm going to just see if I can find your protest here. Just a second, it is. Okay, I do see it's 79 pages long. Hang on, let me get back to you here. Where are you? There we are. I see in the AHO FTP folder, there's a protest that you have with 79 pages total. Is that the one you're referring to?
Yes.
So there are two ways you can do this, and I'll leave it up to you. One is you can just refer to that, and since it's a PDF file with page numbers, if you're citing it in your testimony or your closing brief, just tell us what page number of the PDF file, 67, 78, whatever, so we can find that page. Alternatively, if there's some specific document in that you think you're going to be wanting to refer to a lot, it might be easier for you to just make a new file of that and label that as one of your exhibits and submit it as an exhibit. I mean, we'll get to it either way, but that might be just a little easier way for us to all find it during the hearing.
Okay, and my second question is, when I submitted my NOI, I also submitted some paperwork that was not used in the original petition from Garberville SD. And I wanted to know, I did upload that already, and I will upload it in my own file with the appropriate names and numbers. But I wanted to find out, when we go to either this pre-hearing today or the hearing in June, do we only have to talk about what we've already submitted, or if we find new information, can we submit it and talk about it at that point? Are we stuck with what we included in our original protests, or can we discuss new issues that we've just been privy to?
Okay, and those are good questions. So let me answer them. I think there are two different questions. First of all, I think you already answered your first question. If you attach the document to your notice of intent to appear, please refile that, give it an exhibit name and number, and refile it as an exhibit, because the NOIs really they're not part of they're in the record, but they're a little harder to access. So if you have a document, a historical letter or something, just give it a number, voice 3, voice 7, and file it as an exhibit.
Okay.
The second question, which is also a good one, is what if basically some other party submits something and you say, hey, I didn't know they were going to say that. I want to be able to respond to that. It's not just for you, it could be for any party. And that's what's called rebuttal. I was actually going to get to that in just a minute. So let me get to rebuttal in a minute. And if I haven't answered your question, then you can raise your hand again if that is okay with you. So I'll explain how the process works, and then we'll get to rebuttal. So, and this is discussed in section 10 of our hearing notice on pages 18 through 20. Again, I know there are a lot of words there, but please read them, they're important. The way this is going to work is each party will be allowed to make an opening statement, either the representative or the party himself or herself, which will be a maximum of 5 minutes. It's really just a brief summary of the evidence the party's planning to present. That's not testimony, but just basically a summary of what the testimony is going to be. And then the party will get to present a summary of if its evidence, his evidence or her evidence through the witnesses. And the way we do that is each witness is supposed to submit their written proposed testimony in advance. And then at the hearing, I'll just say, Mr. Smith, if it's only Mr. Smith, it's some party's first witness, please take the oath. Do you swear that you're going to tell the truth and so forth? And Mr. Smith will say yes. And then I'll say as exhibit, 7, your testimony, yes. And then I'll give Mr. Smith an opportunity to provide a brief summary of his testimony. We don't have people read their testimony. I can assure you, I and my staff will have read all of the proposed written testimony ahead of time. Other parties can read it all ahead of time. So that really is an opportunity just for summaries. And I do want to emphasize section 6 of the hearing notice. It's on pages 13 to 14. Explains that and says that we encourage the parties to prepare slides that summarize their testimony and to submit those as a separate exhibit. I mean, you've all been through Zoom meetings over the past year, probably more than that. And no, the slides will just really help you give a concise summary of your testimony. The written testimony is still in the record, but the slides help the summary. But I am going to limit time, so please do not look at the hearing as an opportunity to give your entire testimony in writing, reading it, or a very detailed summary. That's not the purpose of the hearing. And I just want to emphasize that because it's not fair to one party if they stick to summaries and then the next party does not. That's I've got time, but that's not really fair to the parties who play by the rules. So I am going to cut people off. It's sort of unpleasant, but I have to do that to be fair. So I'm going to hold everyone to your timeline for summaries. Then, after each party has its witnesses or his or her witnesses have presented their summaries of testimony, other parties may ask cross-examination questions, and that's basically anything that's relevant to the hearing within that witness's knowledge, and then I may ask questions as well. And we'll go through, all the parties will present their evidence, and we'll go through that process. And now I'm going to get to rebuttal. So Mr. Voice, this answers your question. The hearing notice does talk briefly about rebuttal. It's on page 19. It's in part C of section 10. After everyone's presented their case in chief and their witnesses have been cross-examined, the hearing officer may allow parties to present rebuttal evidence. Rebuttal evidence is new evidence used to rebut evidence another party has presented in its case in chief. You do not need to submit rebuttal testimony or exhibits ahead of time before the hearing. What I will do is after everyone's presented their case in chief, I will ask people if they want to present rebuttal evidence. And we can do it one of two ways. If it's going to be fairly short, I'll probably just have the people have their witnesses testify on the spot and present rebuttal, basically during the same day of hearing or the next day of hearing. If the rebuttal is going to be longer, then I'll probably ask people to prepare written summary or written testimony of their rebuttal, and we'll go through that same process where they then can summarize their written testimony. We'll have an additional hearing day. The one thing that I will insist on, whether it's oral or in writing, is that people are clear what they are rebutting. It can't just sort of be, hey, I thought of 3 other points I want to make and I'd like to make them now. It has to be, well, so-and-so's witness said this and I want to respond to that. That's what rebuttal is, because otherwise this hearing could just go on forever. So I've got to have some limitation on it. But if there's a legitimate thing where somebody said something and you say, no, I disagree, or I think a further explanation of that point is necessary, then we will allow rebuttal. So does that answer, I'll start with you, Mr. Voice, since you raised the question. Does that answer your question about how rebuttal will work?
Yes, thank you very much.
Okay. And of course, it's not just for you. Does anyone else have any questions about how the rebuttal will work?
May I ask a question about the witnesses themselves?
Of course, please.
Okay. Correct me if I'm wrong, but what I heard you say is that each party would take a turn, all their witnesses would testify, and then when all the witnesses were done testifying, then cross-examination of those witnesses would occur? Or is each witness cross-examined as you go?
It's a good question. I think the hearing notice gives me the option of deciding whether to go one way or the other. It's what's called a panel of witnesses. What I normally do is have a party, for example, we'll use yours as an example, Ms. Short, for the Garberville SD. Have all of your witnesses present their summaries, and hopefully with slides, because it will go fast. I think I've given 30 minutes for that whole thing. And again, that's just summaries. And then I will have each party give them an opportunity to cross-examine everyone. All the witnesses will be there on a panel. And of course, they can say which witness they want to ask a question to. I find that goes a lot faster than cross-examining witnesses one at a time, just because obviously that takes longer. And also, very often it is another party will ask witness A a question on cross-examination, and witness A will say, I don't really know much about that, but witness B over here knows a lot about that, and I think it's better for you to ask witness B. And so if they're both there for cross-examination at the same time, obviously we can just shift over to witness B and he or she can answer the question. So unless there's a reason to do otherwise, I suspect we'll have panels where it's all summaries first and then cross-examination of everyone in the panel next. Does that answer your question?
It does. And if I can just ask you a follow-up question.
Of course.
I'm struggling a little bit with understanding the distinction between, as most of the parties on their NOI have stated that the only witness they'll be calling is themselves. How does that work exactly as far as them having to provide written testimony, and then do they just, the same thing will apply to myself. Like, do we just give a summary of the exhibits and then we're just treated like a witness during that one part of the proceeding?
Yeah, it's a little tricky. It's different than court. You've probably all watched court proceedings on TV. You've probably all seen court proceedings where there's an attorney who can ask you questions. And of course, it's hard to ask yourself questions. And the answer is we'll play it by ear. I certainly can ask the general question, is exhibit Garberville SD 17 your written testimony? And you'll say yes. And then I'll say, please summarize your testimony. And hopefully you'll have your slides, which will be Garberville SD 18. I'm just making up numbers here. And you can provide a summary. So normally you don't need to ask yourself questions, but you can just provide the summary and go forward that way. And again, for the other parties as well. We don't require people to have lawyers. Obviously, this is a public agency that is trying to provide access to the public. So that's the way we will normally do that, and it works. And I'll help. I'll help out if I think I need to ask clarifying questions at any point. Does that answer that question?
But you will expect that each party that wants to serve as a witness in representing their own selves, that they will have to provide a written exhibit of the testimony that they want to give during the proceeding by the deadline.
Absolutely, and that is absolutely important. So I'll use the hypothetical Mr. Smith. If Mr. Smith is a party who's representing himself, he needs to submit his proposed written testimony by June 2nd. And then during the hearing, I will say, Mr. Smith, do you take the oath? And Mr. Smith is Exhibit Smith 7, your testimony, and it's Exhibit Smith 8, the slide summarizing your testimony, and please provide a summary. We do not allow people to just show up and testify. They can do policy statements, which are not evidentiary for non-parties, but parties must submit their written proposed testimony in advance. I hope that's clear, but that is very definitely the way we do it. And again, that's just out of fairness to everyone else. It's not fair if one party submits all their written testimony ahead of time and someone else just shows up and starts talking. So I've been involved in water right proceedings before this board, mainly as an attorney representing parties for over 30 years. And that's the way we've always done it. And frankly, it's a pretty fair proceeding because everybody knows ahead of time. It's, to use the metaphor, everyone's putting their cards on the table before we start, face up on the table before we start. And we can go from there. I mean, the bottom line here is this isn't a game. We're not trying to have people get advantages or disadvantages. I'm trying to get to the truth. I want to get the evidence and the legal arguments out there so that I can process them. I can work with my staff to develop a proposed order. So it's not a game. It's a process to get to the truth. So that's why we want the written testimony in advance. And I'll first ask you, Ms. Short, does that answer your question? I rambled on a little bit, but does that answer your question?
It does, and that was what I understood from reading the instructions, but because it's a little different for the party itself to be a witness, I just wanted to clarify that that is the expectation. And as far as Ms. Metz goes for LAFCO, what I'm taking away from what you're talking about for rebuttal is that she potentially will have to stay on the call for hours while every party gives their testimony and wait if somebody wants to rebut what she has to say until the very end.
Okay, so first of all, let me clarify. If you do have your attorney appearing, you can have your attorney ask your witnesses questions. There's no prohibition on that. It's just not required. But as far as, I'm sorry, what was her name? Ms. Metz, Ms. Metz Sanchi.
She's with LAFCO, and she just was asking me, like, how many hours do I need to set aside on June 15th for this?
Okay, well, and so she will, assuming she testifies on behalf of Garberville Sanitary District, she will prepare her summary, and then she will be on the panel of witnesses subject to cross-examination. And then she doesn't need to stay in the hearing after that. If somebody gives rebuttal later on and you think that she has something further to say in response to that, we can make arrangements to call her back as necessary, but she doesn't need to sit through the whole hearing. And if necessary, within reason, I will try to be flexible. If for some reason she, we'll use her as an example, could apply to anybody, but if she has only limited time to appear, we could allow her to give her summary of testimony and have her be subject to cross-examination separate from your other witnesses and finish with her, and then she can move on. I certainly understand she has a real job, a regular job to hold down and may have limited time, and hers are probably fairly discrete set of issues. So if you think that's necessary or she, would like to do that, let me know. Again, send me an email with copies to everyone else, and we'll see. We have some flexibility here, as long as, I just want to make sure whatever I do is fair to all the parties. But again, I'll say it one more time. The bottom line is getting the truth out here. That's what I want to do. So anybody else, these are good questions. Does anybody else have any questions? I'm glad Ms. Short raised the question, but please have your written testimony, proposed written testimony in advance, and be a summary of that. I don't want people to just show up and give new testimony. If you do want to respond to what someone else has offered, we will do that during the rebuttal phase, but not during the initial phase. So, and I'll pause. I've been talking a lot. Any questions about that process? Yes, it looks like Ms. Sutton has a question. But go off mute and then you can ask your question.
There we go. There you go.
Hello.
Good.
Can you hear me?
Yes, now you're good.
All right. I just have a question about the time limits. I think it was really hard to gauge a time limit that we needed. If someone finds they need a little more time, is that flexible, or are we, do we have to just follow very closely the time frame we noted on the notice of intent to appear?
So were you talking about the time for summaries of direct testimony or the time for cross-examination?
I'm not sure of. It asked for a time on, and I don't have my notice of intent, a copy of it right here. Only that I recall, I think my time was ample, but I think Cody Cox, our general manager and operations manager for RCSD, put a very low amount of time on what he thought he might.
Okay, and so let me emphasize again, there's Mr. Cox. You want to say something before I say? Just go off mute and tell me what your thoughts are.
No, go right ahead.
Okay, so let me just emphasize for direct testimony, it's a summary. It's, you know, your written testimony, don't do this, but it could be 20 pages long and I'll read it. You know, some complex matters involving the Bay Delta, the testimony is 20 pages or even more. I don't think for this hearing that'll be necessary, but whatever you think you need to do, put it in your writing, in your written proposed testimony. And then you have slides to summarize that. But the summary is just a summary, and we do have 30 minutes per party, you know, and that includes for Garberville Sanitary District, which is the petitioner here, probably has the most to present, but also for Redway. So I will, unless there's some reason that I'm not aware of, I will hold everyone to 30 minutes maximum for the summaries. And let me just tell you, another state agency, the Public Utilities Commission, does hearings, you know, on things within its jurisdiction. They don't allow summaries at all. Their hearings are, you know, witness A, Mr. Smith, is that your testimony? Yes. Okay, parties may now cross-examine Mr. Smith. So the whole idea is your written testimony is where you say it. You don't say it in the summary. So again, I hope I'm not sounding too harsh about this, but trust me, this process works. I've seen it on both sides, both as an attorney representing parties and as hearing officer. It does work, and we go forward. Now, the one time when time limits may need to be extended is on cross-examination, because obviously you don't have any control, or not as much control, over a witness you're cross-examining, some other party's witness. So if somebody says, you know, I've covered these 3 subjects, but I need to cover subject 4, I may allow more time. But again, there's got to be some reason for it. You know, these hearings could drag on forever otherwise, and you know, especially with the drought coming, we have a lot of things going on in this office. So we want to give everyone a fair hearing, but we want it to be efficient. So this is a very important topic. Any other questions on this topic? Just raise your hand if you do. It looks like Ms. Hino Barasa is raising her hand. Please go ahead.
Thank you, Mr. Lilly. Yes, and I just want to say from the park standpoint, you know, as you know, we're a 501c3 and we have to fundraise for every step of this process. And it's getting very costly. We do have to, we are charged by GSD for the time of all the experts that have to appear and all the research that they have to do. So it would be beneficial for us if we knew that the time was going to be pretty strictly adhered to, because I as a treasurer have to budget for it. And we've already, you know, several thousands of dollars in debt just to get this application to the point where it is now. And the park, it's not their first attempt. It's an ongoing thing for, you know, close to 20 years. So you can imagine that this is an exciting time for us, but also it's a little nerve-wracking because we're all volunteers, and we just want our community to have this beautiful venue and to be able to provide safe drinking water to people that use the park when they need it. So okay, well, I want to put that out there.
Yeah, let's not get into arguments about whether the petition should be granted or not. That's for the hearing.
Yeah, no. I just want the process itself, because you can understand where this particular application is 2 years in now.
Yeah, but okay, yeah, you know, please don't get into arguing anymore. But your point is clear. You want this to be an efficient hearing, and I do too.
Thank you.
So, I mean, you will see, I'll do the best I can because there are tensions. I want to make sure everyone has an opportunity to present their arguments and get their evidence there. But beyond that, I want it to go quickly because, you know, I mean, I get paid to do this, so it's not my time that's the most important thing. But all of you have other things, budgetary constraints and so forth, and I do want to respect that as much as I can. Well, of course, making sure we have a fair hearing. So so that we will be efficient but fair.
Thank
and I
you.
will do all I can. Okay, any other questions on that? Okay, you're not raising your hand again, are you?
No, I'm gonna,
Or you're okay, that's good, that's fine. Thank you. The hearing notice refers to, we can do either closing statements or closing briefs. I'm to page 20, you're probably all happy, I'm almost through the hearing notice. My plan is to have parties submit written closing briefs rather than oral closing statements, frankly, for two reasons. Number one, and we'll talk about the schedule for those. They'll be due a few weeks after the end of the hearing. I think the written statements are better for you and for me. I mean, it gives you time to sort of think out your arguments rather than just having to do it on the fly right at the end of the hearing. And also it gives me and my staff then something in writing that we can refer to when we're going through that party's arguments to prepare our proposed order. So unless something really changes, I just wanted to let you know, my plan will be to have, we'll get done with the last witness. I'll talk to all of you about setting a schedule and a deadline for filing closing briefs. We will have page limits on them. I don't think they need to go on forever. And then I will ask everyone to just file those rather than doing the oral closing statements. So we've covered this pretty well. I think we've covered everything, but does anyone have any more questions about the hearing procedures? All right, and we'll give you one more chance later, so don't worry if you forget something. I did want to talk about the April 4th email from Ms. Short to Michael Meza. And I think most of you have probably seen this. We did post it to the HOFTP site. It discusses a proposed permit and license term that are in the draft license and draft permit that were attached to the hearing notice regarding the cannabis cultivation policy. Ms. Short's email asked questions about whether this term would apply to Garberville Sanitary District. Her email states that none of the four circumstances listed in Section 3, Part 2 of the cannabis cultivation policy apply, and therefore asks whether the term, and particularly the in-stream flow requirements in the policy, would apply. So just for those of you who haven't seen the policy, the policy, if no one else puts it in the record, we will. It is posted on the Water Board's website. But basically, the section that Ms. Short is asking about states the in-stream flow requirements and forbearance period, that's when the party's not allowed to divert, listed in this section shall not apply to retail water suppliers as defined in Section 13575 of the Water Code, whose primary beneficial use is municipal or domestic, unless any of the following circumstances are present. And they're A through D, 4 circumstances. A is the retail water supplier has 10 or fewer customers and delivers water that is used for cannabis cultivation. B, the retail water supplier delivers 10% or more of the diverted water to one or more cannabis cultivators or cultivation sites as established by an accessory parcel number. C, 25% or more of the water delivered by the retail water supplier is used for cannabis cultivation. Or D, a cannabis cultivator and the retail water supplier are affiliates as defined in California Code of Regulations, Title 23, Section 2814.20. So, Ms. Short, I want to tell you how I recommend that you and the district address this issue. And we are not in a position to answer your questions at this time, because among other things, I mean, you said that none of these 4 conditions apply, but we don't have any evidence, any sworn testimony on that. So what I recommend you do, and you probably will want to work with your attorney on this, is as part of the district's evidence in its package of exhibits and testimony, I recommend you submit testimony that demonstrates that none of these 4 circumstances applies. And then in the district's closing brief, that can address that, discuss that evidence, and then say, or discuss what terms the district thinks the Administrative Hearings Office, my office, should include in the proposed order to address this issue. And then for any other party, they also may submit exhibits on this issue and make arguments on it in their closing briefs. And I will add this as a list to the list of hearing issues. With that process, then I can evaluate the district's evidence and arguments, any other party's evidence and arguments as we prepare a proposed order. And then the proposed order that we prepare that ultimately the board will consider adopting will have a ruling on that. That's going to be the fairest way to give all parties an opportunity to present evidence and argument on the issue. It's going to give me a fair chance to analyze that evidence and argument. And also then it will be in the order, which will be better for the district, assuming the order goes the way the district wants, to have something in an order adopted by the board rather than just some oral statement by me or an email by me clarifying that. So that's how I plan to go forward on that issue. It's an important issue. It's a fair issue, but I'm throwing it back to you, Ms. Short, and the district to prepare and submit evidence and arguments on that issue. And of course, that gives all other parties opportunities to submit evidence and argument on the issue as well. So does anyone, I'll start with you, Ms. Short, since it was your email. Do you have any questions about that plan for going forward?
I do. I have no issue with what you're proposing and would be happy to submit both testimony and written exhibits that prove that none of those four things apply to us. But for me, it's a bigger issue in general because for the last 2 years, as part of our annual reporting, there have been questions related to cannabis. And what I'm really looking for is somebody who can explain to me what the expectations of the district are in that reporting, because this is in some ways external completely from this proceeding. The Water Board has been implementing some of these issues surrounding cannabis totally outside of amendments to permits. And we're a really little district and we're trying to figure out, okay, in this, 80-page document, none of it seems like it applies. And yet we're being asked for information the last 2 years in our reporting, and now it's being specified in our water permit. What does that mean for us from a practical standpoint?
Okay, well, and this is it's a fair question, but it's complicated because the Division of Water Rights people who are handling reporting, normally they will give you an answer, but they're concerned about doing something that would interfere with this hearing process. So let me just ask, your annual reports for your water right license and permit were due on April 1st. Did you file those by that deadline?
We did, and we included answers to all the cannabis questions that we had information for. But some of the questions are fairly detailed and go far beyond anything that we know.
Okay, so I'm in a bit of a quandary because I don't think, these are important issues and I understand why you want answers, but I don't think they are answers that concern the issues or that your questions are related to the issues for this hearing, which just concerns the change petition. These are general reporting issues. So
they are. That's why I asked Michael for a contact person. It's because he has been really helpful in this, and all the searching I did online, I could not find anybody to actually ask my reporting questions of.
Okay, so here's what I'm going to do. I'm going to try to cut this off and separate it from our hearing. But I will work with Mr. Anderson, of my staff, who's quite knowledgeable about the reporting requirements. And we will send you an email with, of course, copies to all the other parties and a paper copy to Ms. Sutton, and give you the name of the contact person within the Division of Water Rights Records Unit. They do have a person who's, or a section of people who are set up to answer questions about reporting. And I will give you that contact information and you can contact that person. I will CC them on my email as well and say, I don't think any of this has anything to do with this hearing. So please, don't feel constrained to discuss these questions with Ms. Short to the extent they don't relate to the hearing. And hopefully then you can deal with that in a totally separate process and It does not need to be involved in this hearing.
That would be great. I
So
appreciate that.
No, it's not just for you, but for anybody who files annual reports with the water board. Of course, the water board wants those to be as accurate as possible. I mean, they're very valuable for the water board's database for trying to manage water resources, what's left of them in a dry year for the state of California. So we want to try to help people file accurate reports, but of course we don't want it to undermine our hearing process. So we will do that. And then as far as the specific permit term, you can address that with your exhibits, testimony, and closing brief for the hearing. Because the hearing, the proposed permit term is directly related to hearing issues. So that should be addressed during the hearing. And the reporting you can do separately. So
Okay,
I hope
thank
that
you.
makes sense. We will do it that way.
Sounds good.
Okay. Does anybody else have any questions about anything we've covered today? I appreciate your patience. It's taken us over an hour. I've done most of the talking, maybe too much, some of you would say, but I'm trying to explain how I want this to go forward. So does anybody have any questions before we wrap up today?
I have one last question if nobody else does.
All right, go ahead, Ms. Short.
I just wanted to know how much are you going to limit the testimony and the summary and the cross-examination to issues that are directly related to the license and the permit, as opposed to the whole host of random comments and complaints that the district has dealt with, down to things like whether LAFCO waives part of their fees and does the Park Board hold public meetings, and things that really don't have any direct relation to what the Water Board oversees. I want to try to streamline my testimony down to things that seem like they're directly related to the permit and the license. But if others are not gonna, if you're not gonna limit it to that, then I probably am gonna have to be much broader.
Okay, and the answer is it's pretty hard for me to give a pre-ruling on what could be a whole bunch of different issues. But the way I will go forward, the way I always go forward on questions like this is, if, let's suppose one of your witnesses has presented his or her summary of testimony and it's being subject to cross-examination, and either you or your attorney, if you have an attorney, thinks that the cross-examination question does not relate to any of the hearing issues, then you can say that. You can object, say objection, I don't think this question relates to any of the hearing issues. And then I will ask the questioner, Mr. X or Ms. X, please explain how you think this relates to any of the hearing, which hearing issue you think it relates to and why. And then they will give their explanation, and then I will give a ruling. But that's similar to how court processes go forward. I mean, it's basically, in legal terms, an objection on relevance grounds, which we certainly will consider. I mean, I have no idea how I will rule. It'll depend on the question and the objection and the explanation. But that is why we take a lot of time to prepare the hearing issues, so that, because they really define the scope of the hearing, and I will limit questions to those that are relevant to hearing issues. I mean, I don't know of an example of one that's not relevant. There are a lot of things, that would not be relevant to those hearing issues, and we won't allow those just because they're not relevant, and we need to go forward. So, okay, does anybody else have any questions about that or any of the other hearing procedures? Okay, I don't see any hands, virtual or video hands raised, so I will assume that means no. I will put together an order. I do have a couple of schedule conflicts in the next few days, so it may not be until the end of this week or early next week, but I will get the order out. I did want to just reiterate, I'm sure you all know, but just a reminder, your exhibits and testimony need to either be uploaded or filed in paper by June 2nd at 4 p.m. And that includes proposed written testimony and summary slides. And then the first day of hearing, we will conduct by Zoom on June 15, starting at 9 a.m. I look forward to all of your participations then. If any of you has any updates to the service list, the new service list that I'm going to send out, please send an email to the AHO, again with CCs to the other parties, with the updates. I do want to try to have as up-to-date of a service list I can, so make sure everyone gets all the notices. So with that, not seeing any more hands, I will go ahead and sign off. Thank you all very much. You've all behaved very professionally today. And I hope this will help make the hearing process go more efficiently. So I will look forward to your filings on June 2nd and to talking to you all on June 15th. In the meantime, have a good day.
Thank you very much.
Bye.